Hello, legal scholars. Welcome to another episode of Nigerian Law Simplified. My name is Chukwubike Monomajiro, and I'm your facilitator on this amazing learning journey. Today, we are going to be considering the definition of a contract as well as the elements of a contract. So, without wasting any time, let's dive right in. When most people think of a contract, they imagine themselves signing legal documents with lawyers present and probably in one boardroom or one big office somewhere. While this is one of the ways of entering into a contract, majority of the contracts entered into on a daily basis are unwritten and have nothing to do with signing any documents actually. A contract must not always be in writing. In fact, it can be done orally. In fact, sometimes a contract can be entered into without speaking a word. For instance, when you buy biscuits from the shop on your street, or you enter into a keke or taxi that is going to take you from place to place, these are all valid contracts in the eyes of the law. But how many documents did you sign? None. As a matter of fact, majority of the contracts we enter into on a daily basis do not require signing any piece of paper. So, what exactly is a contract? In the simplest terms, a contract is a binding agreement. Now note that there are two key words there, agreement and binding. No matter the definition of contract you get anywhere, these two terms will always be present. There must always be an agreement, and that agreement must be enforceable by law. In the previous video, I already explained the two key terms, agreement and binding. You can go back and listen to what I said in the previous video. But for the purpose of this topic, let me go ahead and x-ray them further. An agreement starts with one party clearly communicating to another party that he intends to be bound by certain defined terms. This communication of the intention to be bound by those defined terms is what we call an offer in contract law. Note that at this point of making an offer, no agreement has been reached yet. This is because an offer is only one half of the agreement. It is only one component, and it needs another component before it can be fully formed into an agreement. So, an agreement only becomes complete when the other party to whom the offer was communicated decides to be bound by the same terms which were communicated by the first party. Now, this decision to be bound by these terms is what we call an acceptance. Note that the second party must be accepting the same terms that were communicated by the first party in his offer. Where the second party does not accept the same terms, then it cannot be said that he has accepted the offer by the first party. So, an acceptance must be based on the exact same terms communicated by the first party. This is a very important point because for an agreement to properly occur, both parties must clearly understand the terms of the agreement they are entering into. Where this is not the case, then the parties cannot be said to have achieved what we call consensus ad idem, the meeting of the minds of the parties. And this is the essential point of an agreement. There must be a consensus ad idem. There must be a meeting of the minds on exactly what they are agreeing to. And this meeting of the minds must be done voluntarily by both parties. There must be no element of coercion or duress or force of any kind. Both parties must be coming to that point of consensus ad idem voluntarily and independent of any factor that can vitiate that agreement. Now, this is a visual representation of how an agreement is formed so that it will aid your understanding. The offer plus the acceptance is equals to the agreement. The offer is the communication of the intention to be bound by certain defined terms. The acceptance is the decision to be bound by the terms stated in the offer. When these two things come together, we have the agreement. The agreement signifies the consensus addendum between the parties. And we said that this consensus addendum must have been reached voluntarily by both parties. One important thing to add here is the aspect of formality, because sometimes the law requires certain formalities depending on the kind of agreement that is being reached, the form that the agreement must take. A quick example of that is when you're entering into land agreements, it is required that they be in writing. Those agreements are in writing. So that's what we mean when we say formality. So if there is a certain legal formality on that kind of agreement, then it is important that the agreement complies with the legal formality. When all these things are in place, you have an agreement. An agreement is the foundation of a contract. Every contract starts out as an agreement between two parties, but it is not every agreement that will qualify to be called a contract in the eyes of the law. This is why it is said, all contracts are agreements, but not all agreements are contracts. So it is only agreements that are legally binding that can be rightly called a contract. Let me explain this further. Do you remember when you were in primary school and your parents promised you that if you come first in class, they are going to buy you a bicycle? Yes, that was a promise they made to you. And because of that, you accepted, yes, mommy, I will do my best to come first in class so that you will buy me a bicycle. You have reached an agreement with your parents. But the question then is this: is that agreement binding in law? So when we say all contracts are agreements, but not all agreements are contracts, this is what we are referring to. At the moment, you have an agreement with your parents, but will that agreement be considered as binding in law so that it can be classified as a contract? That brings us to two questions we must answer. First, what does it mean for a thing to be binding? And second, how do we know when an agreement is binding? So let's go to the first question. What does it mean for a thing to be binding? It simply means that such thing is enforceable by law and must be adhered to or complied with. Where an agreement is binding, the law will ensure its adherence or compliance by force. So when we say something is enforceable by law, we mean that thing is binding. The law can force that thing to be complied with because it is deemed binding in law. So going by our earlier definition, a contract is a binding agreement. And where an agreement is deemed binding, it means that the law will enforce such agreement and ensure its compliance. So what distinguishes a contract from a mere agreement is the enforceability, which results from its nature as being binding. That is why in the case of Orient Bank Nigeria PLC against Bilante International Limited, the court defined a contract as a legally enforceable agreement. Any agreement that cannot be legally enforced is not a contract. Only an agreement that has the force of law behind it, that is deemed binding, that is deemed legally enforceable, can then be classified as a contract. This is why the eminent jurist Sir Frederick Pollock defined a contract as a promise or set of promises which the law will enforce. So the question is, why will the law enforce some agreements or some promises and not enforce the others? There is something that the law looks at to determine whether or not an agreement is binding and whether it will be enforceable. So let's move on to the next question, which is, how do we recognize a binding agreement? In order for an agreement to be recognized as binding in the eyes of the law, such agreement must possess certain elements and qualities. Without the presence of these elements and qualities, an agreement cannot be deemed binding or legally enforceable. So what are these elements and qualities that make an agreement to be deemed as binding and to be seen as legally enforceable in the eyes of the law? These elements include capacity, consideration, intention to create legal relations, and legally enforceable obligations. These are the elements and qualities that must be merged with an agreement in order to be deemed a binding agreement, aka a valid contract. So, as already explained, an agreement is a combination of the offer and acceptance. And this offer and acceptance must be done voluntarily by both parties. And when entering into this agreement, they must also make sure they consider whatever legal formality the law requires for such agreements. Going further, the element of capacity entails that the parties involved in the agreement must have the requisite authority and qualifications to enter into the agreement. This means that the person making the offer must have the capacity to make that offer, and the person accepting the offer must also have the capacity to accept that offer. For example, if I make an offer and say, any lady, any girl that comes to cook for me, I will give her my father's car. I don't have the capacity to make such an offer because my father's car is not my own. And in the same way, if a boy comes and says, oh, I'm the best chef, I will cook for you, he is already disqualified from accepting that offer because by virtue of his gender, he does not have the requisite qualification to accept that offer. Then under the element of consideration, it is required that under simple contracts where the law requires it, there must be an exchange of something valuable between both parties for such agreements to be deemed binding. However, it is important to note that there are some agreements in which the law does not require consideration. Then on to the element of intention to create legal relations. Both parties involved in the agreement must know that they are creating a binding agreement. It's not play. Both parties must have intended that by virtue of their agreement, they are creating duties and obligations which they must both perform or face the consequences. And that brings us to the final element, legally enforceable obligations. The duties and obligations which are created as a result of the parties' agreement must be compliant with law. They must not go against the provisions of law. Where the duties and obligations in a contract are things that go against the law, things that are not in line with the law, then such contract will not be deemed enforceable. For instance, where two people agree to go and commit a crime, such contract is not binding because the obligations created by the contract are not such that the law can compel one of the parties to fulfill. The law cannot force a person to go and commit a crime or punish somebody for not complying with the agreement of going to commit a crime. That would be against everything the justice system stands for. So there you have it. An agreement plus capacity plus consideration plus intention to create legal relations plus legally enforceable obligations equals to a valid contract, also known as a binding agreement. These are the elements that come together to make up a valid contract. Where these elements are not present in an agreement, such agreements cannot attain the status of becoming binding. Each of these vital elements of a valid contract will be discussed in detail in subsequent episodes. That is it for today's lesson. Please feel free to rewatch this video as many times as necessary until you understand it clearly. Also, don't be afraid to drop your questions in the comments and I will attend to them. Speaking of questions, here are 6 questions that are going to ensure that you have truly understood this topic. As usual, thank you so much for watching this video. Ensure that you subscribe, like, and share this video with all your colleagues. I will see you in the next lesson.